Hi, I'm Paul McConnell from the McConnell Family Law Group. I'm going to go over everything that we typically cover in an initial consultation in terms of the law. All right, so there's a number of different topics to talk about. First of all, there's different methodologies in which to get divorced. What do I mean by that? In other words, there's different paths you can follow, and they all lead to the same destination of a dissolution of your marriage by the court. The end, the court is always involved at the very end, but it's not always involved along the way. So there's basically three major different pathways that are methodologies that you can follow. One is litigation, two is mediation, and a third is collaborative law. And I'll talk about each of those, and there's some pros and cons to each, and there's some other videos on these topics as well. But in a nutshell, litigation, okay, that's probably the most common in terms of what you've seen on TV or you've seen in the movies. You or your spouse hires an attorney. They file a complaint or divorce papers, and they have the other side served, who then hires an attorney, and you go through the attorneys to negotiate and, if necessary, to litigate in a court. That's why it's called litigation. Now, even the litigation model, though, less than 5% of the cases actually go to a trial where you can't reach an agreement and a judge is asked to make a final decision. 95% of the times, even in the litigation model, the cases are resolved through negotiation and ultimately a settlement. So that's the litigation model. Mediation, which is a very large market share, is where you represent yourself. But hold on, I'll get back to that in a second. You represent yourself and you meet with a neutral mediator, and the mediator leads the discussion and make sure that you talk about all the topics that need to be talked about, and you negotiate back and forth and ultimately reach an agreement on all the areas that need to be agreed upon. And the mediator then memorializes the agreement, and you get to your destination now. In the mediation model, oftentimes the individuals, the husband and the wife, will each have an attorney called a review counsel. But in the mediation model, those attorneys don't come to the mediation. So you're on your own at the mediation, but you have an attorney in the background that you could call ahead of time or afterwards, and he or she can look over the documents from your point of view before you sign, called a review counsel. Then there's the third methodology or pathway, and that's something called a collaborative divorce or collaborative methodology. And then that's a little bit of a hybrid, and that is it's non-adversarial like mediation, but like litigation, you have attorneys by your side the entire way. In the collaborative model, you would hire an attorney that's collaboratively trained. Your spouse would hire an attorney that's collaboratively trained. People sign a collaborative agreement that's committing them to this non-adversarial process, and you're committing to not going to court except at the very end. But you'll have attorneys to help you frequently. You'll have other neutrals involved in this process. By neutral, I mean a financial neutral, so either a CPA or a certified divorce financial expert that helps out. And by neutral, meaning they don't represent one side or the other. There's somebody in the middle. They help gather information and produce options and courses of action for dividing assets and the like. Sometimes when there's children, and even sometimes when there's not children, there's another mental health neutral involved. In the scenario where there's children, that person typically helps produce the parenting plan and works with the parents in that regard. So that's the collaborative methodology. There's other videos and resources on our website that can help answer some more questions with respect to any one of these methodologies. There's some pros and cons to each. And again, it depends what's best for you, but please look at some other videos if you want to see if mediation may be right for you, or if not, litigation, and if not, obviously collaborative law. Now, mediation is about 40% less than litigation. Collaborative law is really about the same as litigation, assuming that there's no trial. Obviously, if there's a trial in those 5% of cases, that's by far the most expensive. But collaborative is about the same, even though you have these additional timekeepers like the financial neutral or the mental health neutral, and we all work our meters running. You have these additional timekeepers, meters running. It seems like it'd be a lot more expensive, but there's also some cost savings measures involved, so it kind of offsets it. It's on average, some people are going to tell you it's less than litigation. Some tell you it's more. It's my experience. It's darn close. It's darn close. Maybe a little bit more has been my experience. We do at McConnell Family Law either litigation or collaborative or mediation, depending on what's right for our clients. Okay, so those are the different methodologies that lead to the same end state, that being a dissolution of the marriage. One of the most common questions people want to know, how long is it going to take? We tell people to plan on about 9 months. Doesn't mean every case takes 9 months. Some cases can be done as little as 3 months. Some last a year or much longer, particularly in those few cases in which there's a trial. But we tell people to plan on about 9 months, maybe a little bit less, maybe a little bit more. If you want to talk to us about your particular situation, why you believe it may be only 2 or 3 months, okay, we'll talk to you about that. In addition, people want to know, how much is it going to cost? Well, I'm going to give you a lawyer answer. That is, it depends, but I'm going to talk a little bit more about costs at the end. All right, some additional things to talk about, and that is no fault. What is no fault? The only thing no fault means is that in the old days, back in the 40s and the 50s and like before then, people had to allege, for example, mental cruelty. And if the other side contested it, there would be a dispute and somebody would have to prove a fact in order to get divorced, or if not mental cruelty, then substance abuse and the like. There was a trend and started in the 60s and 70s for no fault divorce. And that is, if one party wants to get divorced, the other side ultimately really can't stop it. All you have to do is allege that in Connecticut, that the marriage is broken down irretrievably with no help of reconciliation. And if you allege that and you were to testify to that, the court would credit that, and the other side could not stop divorce from happening. So that's essentially what no fault divorce means. Okay, another proposition that you would need to know about is equitable distribution. And what we're talking about now is how to divide up the marital pie, the assets and the debts of the marriage. Connecticut is an equitable distribution state as opposed to a community property state. All that means is that Connecticut passed a statute that has a number of factors listed in it that a judge needs to consider before deciding how to divide the marital pie. Now, those equitable factors are such things as the age of the parties, the length of the marriage, the amount and sources of income, the ability to acquire more property in the future, and the like. In practice, the way that plays out in Connecticut, the way courts typically apply that judicial norm, is that all the property, even prior to marriage, even inherited property, all of it's on the table to be divided. But in practice, for medium and long-term marriages, the court is going to have a starting proposition that the marital pie will be divided 50-50. Doesn't mean each asset and each debt will be divided 50-50. Just means get all the assets and debts on the table. And the starting proposition is that each of the parties are going to walk away with 50%. And I said medium and long-term marriages. So I mean, anything in Connecticut, this isn't written anywhere in the law, but we often think of short-term marriages as 0 to 10 years, medium-term marriages 10 to 20, long-term marriages 20 to 30. And there's not necessarily a black and white mark as between 19 and 21. But that's kind of the range in areas. The courts treat these different marriages slightly differently in deciding equitable distribution and alimony and the like. So that's what I meant by medium and long-term marriage. So in medium and long-term marriages, typically the starting proposition is 50-50. There's some exceptions to that in terms of all the property. That is, sometimes if somebody's inherited some property and that hasn't been commingled, then oftentimes a court will carve that out. So if somebody inherited an expensive piece of art, for example, oftentimes say it's worth a lot, a court will just keep that with the spouse whose family it came from and not make that part of the division. Sometimes student loans will just follow the person who got the education that correlates to those student loans. It's not to say this happens in every case. Sometimes inheritances can be cash or IRAs, and it depends how long it's been held and whether it's commingled and the like. So not every inheritance is treated differently or carved out, I should say. So that's the starting proposition, and there's some exceptions. There can be fault as one of the factors that can be considered, and so sometimes if there's been a tremendous amount of mental cruelty or extramarital affairs and the like, that can change the dynamics to make it something other than 50-50. This is financial orders we're talking about, so alimony, which I'll talk about in a few minutes, and child support, those are also financial components, and courts consider the overall mosaic of a family marital pie. And so if they're doing more or less with alimony, that may or may not impact how the equitable distribution is broken out. Okay, but those are some general propositions. Starting proposition, typically 50-50. Sometimes in the shorter term marriages, like 0 to 3 years, 0 to 5 years. Courts sometimes often, is there a way we can just return this people to the way they were before they got married? Forget about 50-50. A lot of times courts, even though all the property is typically considered, will then thereafter really only consider the property that was acquired during the marriage, even though technically all of it's on the table. Let's just look at what's been acquired during the marriage. And that can come into play, for example, with retirement accounts. If somebody had a 401k and 10 years ago on the date of the marriage, and we can determine it was worth $100,000 at that time, and then it's grown to $200,000 during the marriage, and that can be identified. Oftentimes, the court will carve out that 100,000, and then that growth in investments during those 10 years of marriage from 100 to 200, that would be the marital property that would be divided 50-50. Okay, so that's some general propositions with respect to equitable distribution. Okay, so if people have children, there's child support. And child support starts off as a very objective number, and that is Connecticut follows a statute that implements the child support guidelines. And then there's family law software that all the courts and practitioners in this area rely upon. And it starts off by you plug in what the husband makes and what the wife makes, or what the father makes and the mother makes in terms of income. And then it takes out the mandatory deductions of taxes, and you look at the net income, and then how many children there are, and then out comes the number. And it depends on the income level. It depends on the number of children, but there out comes this number, and that is the presumptive amount. Okay, and then there's some deviation criteria that courts can deviate from that presumptive amount. Okay, but you start off with, that's the presumption. You would need to persuade me why we should deviate from this presumption. And sometimes people deviate by agreement. Some of the deviation factors include overall coordination of family support. Sometimes one or more of the spouses needs to travel a great distance in order to exercise. Parenting is sometimes a factor in which to deviate and the like. But child support, by and large, is pretty objective, and courts are pretty hard to persuade. In the absence of agreement, they're hard to persuade off of that objective number. Now, we talk about in another video about child support in high net worth cases, because the child support guidelines only go up to a combined income of $4,000 a week. And then it gets a little bit more complicated in some high net worth cases, and we have a different video on that. But child support, by and large, objective. Spousal support, sometimes called alimony, is much more subjective. Alimony or spousal support is not in every case, but it is in a lot of cases. It's in a lot of cases, for example, where one of the spouses left the workforce to raise children for a period of time. And part of that marital contract was agreed upon, that one spouse was going to focus on being the provider, and he or she was advancing their career, and the other spouse, by the marital contract, was focusing on raising the family's kids and to put them in the best possible chance for success according to how that family viewed things. And parents may not have always agreed exactly as to whether the one spouse should go back to work, and if so, for how long and for how much. But if that's how it played out, okay, then that's likely going to be an alimony case. Other times there's alimony cases even when there is no children. If there's a big disparity between what one spouse makes and the other makes, there's oftentimes courts are going to award some alimony for a period of time to make it closer. Now, this doesn't mean that the payor is going to make it all the way to 50-50, but it could be somewhat closer, for example, 60-40, and there's somewhat of a gray area there. The other gray area is the length of time, that is, how long alimony is going to go for. That we were having this conversation 10 years ago is, well, often for longer term marriages, alimony would be for life, but we kind of seldom see alimony for life. And also, if we were having this conversation 10 years ago, there was often a discussion that time and time again, and you even hear it nowadays, is that alimony would be for half the length of the marriage. You may read about that on the internet somewhere. That is still kind of a starting point in terms of discussion, but courts rely on that proposition less and less in terms of the duration for alimony. In terms of how much, in that scenario where there's children and there's still child support involved, if you were to add child support and alimony together, it's not uncommon that for a period of time that would be 50-50. It's also not uncommon, I should say, that it would be adding child support and alimony together, that it would be 60-40. If there's no children and the children, either there was never any children and the children are now adults, and it was a situation where there's just a big disparity in income, it wouldn't be uncommon for it to come down, not to 50-50, very, very unusual for that to happen, but closer to 65-35, maybe 60-40, maybe 70-30. It depends. And it also depends on the length of time. So in the part of the negotiations, if somebody really thinks that they need it to last 10 years, and the other side really thinks it could be 5, okay, well, rather than just splitting the difference in 7.5 or relying upon a judge to make the judgment on just the duration, you can talk about, all right, how about a little bit less money for a longer period of time, or a little bit more money for a shorter period. There's something called lump sum alimony that doesn't come out, or is never awarded really, very rarely, as the product of an actual trial, a litigated case with a trial, but it's somewhat common in cases via agreement, whether that's via mediation or the litigation model via settlement or collaborative divorce, where there's lump sum alimony. And that is, rather than pay periodic alimony or a stream of income of, say, whatever, $2,000 a month for 48 months, okay, rather than do that time and time again, what's the present value of that stream of income? And we can get an accountant or a certified divorce financial analyst typically can figure out, depending on what the present value is that of that amount is, factoring in an appropriate discount rate would be, and to factor in the time value of money. And then there's the consideration, okay, well, that's dollar money in the hand now. Should maybe that person should or shouldn't take a little bit less than that because they're getting it all up front. And that's a matter of negotiation. There's trade-offs, of course, in other areas of divorce as well. So the lump sum alimony then would allow the payor just to pay that lump sum, and then that would be it. Alimony's done. Okay. If alimony is not a part of your case, it can never be brought up. You can never try to get it later. Okay. So sometimes in cases, if it's a close call about alimony, whether it should or shouldn't be, maybe somebody just was making a lot of money before and they just lost their job. So we don't really expect to get any alimony from them now. Well, we would ask for $1 a year to preserve the right to modify it later. Because if you don't get it in the first place, you can't modify it later. It's just terminated forever. Okay, so that's alimony and child support. Now, if you have children, okay, obviously you want to know about custody and the like. So in Connecticut, the strong presumption with respect to custody, legal custody, is that it's going to be joint legal custody. I'm not talking, doesn't mean one spouse may not have, doesn't mean 50-50 parenting time. I'll talk about that in a second. But the presumption is, and it happens in 95% of the cases, unless somebody's incarcerated or there's really some documented substance abuse and the like, it's going to be joint legal custody, meaning the parents are going to share in all the decision making, any important decisions in the children's lives. For example, God forbid there's any medical procedures that need to be done. They share in important decisions with respect to education and the like. And then the day-to-day decisions are made by whichever parent has the physical custody of the children at that time. And then parenting agreements in terms of how much time the mom or the dad get, they take on a whole different bunch of patterns, depending on the facts and circumstances. To give you a few examples, more and more, usually fathers, have been able to get more and more to the point where they get 50% of the time if they want it. If a father, and that didn't used to be the case historically, but now, if a father has the ability to provide for the children 50% of the time and he wants it, then that's going to be the default with most of the courts. And then if it's not going to be that, somebody's going to have to persuade it off of it. Now, that doesn't always make sense, okay? And people don't need to see this as some sort of badge if I can get the 50% or I don't get it. It's not what it's about. It's about setting up the best parenting plan. It's going to be best for the kids from their point of view. That may be 50%, but it may not be. And so oftentimes one of the spouses has to travel a great deal for their work. Okay, well, then maybe it makes sense to have a longer weekend, a Thursday to a Monday, for example, or make up some more time in other cases because the spouse is traveling and can't participate during the week. So there's lots of discussions that have to go on with respect to what's the best parenting plan. With respect to a true 50-50 shared parenting, it's very unusual unless the kids are older, where it would be 1 week with mom, 1 week with dad. It's typically either a 2-2-5 or a 2-5-2, meaning, for example, One plan might be every Monday and Tuesday with mom, every Wednesday and Thursday with dad, and then you alternate weekends, Friday, Saturday, Sunday. 1 week with mom, 1 week with dad. Okay, so in some cases, then the parent is getting the children for 5 days in a row under that scenario. Okay, so that's a consideration when the kids are really young. Okay, maybe that's not best, in which case it might be where, okay, week number one, Monday and Tuesday, mom, Wednesday, Thursday, dad, and then the following weekend, mom again, Friday, Saturday, Sunday. The following week, that Monday, Tuesday, dad, okay, and then Wednesday, Thursday, mom, and then weekend, dad. Okay, so it's another way to do it. And then there's other ways as well. Sometimes, in some cases, whether it's a litigated case or a collaborative or a mediation, any of those methodologies, sometimes we will farm out or recommend that parents go meet with one of a number of mental health children's therapists and psychologists and the like to help develop a parenting plan. So sometimes we farm those out and the parents meet together with an expert that helps them talk about what's going to be best for their kids, and understanding that it can change and should be relooked at about every 3 years. Obviously, what's going on with the kids when they're in kindergarten, early elementary school is different than middle school and high school and the like. Okay, so one parent would in some cases, will likely have primary residence unless it's truly a 50-50 shared parenting plan. And that's just kind of a byproduct of a bygone area. It doesn't really matter what you label it, but it is typically labeled as the primary residence. And the other parent will have liberal access and visiting time according to whatever the schedule is. Sometimes it doesn't need to be specifically stated as primary residence if it's a true 50-50 sharing plan. Sometimes we still did that because the school district needed it, but nowadays that's not really the case. Okay. All right. Sometimes people want to know about legal separation. Maybe I just want to get legally separated instead of divorced. And what we would say to that is it's pretty unusual nowadays. And what I mean by that is people can separate, all right, if you just want to, you're not sure if you want to get divorced, you can separate and live in separate households, for example, and just try living separate and take a pulse after 6 months or after a year when you want to try again and recommit or work with a marriage therapist and the like, or maybe you already are and you just want to try living separately. That's not a legal separation. That's just an agreement to live separately. And you can even agree on how you're going to divide expenses and the like and costs and et cetera. A legal separation is more of a term of art. And what that means is you're going to get a court to approve it. All right. And in order to do that, you go through all the same steps you do in a divorce. That is, you collect all the financial information and the discovery needs to be exchanged, and you produce financial affidavits. The financial affidavit is the most important document as it relates to finances. In a divorce case, after you get records such as taxes and bills and the like, each side has to produce a financial affidavit that they swear to, that's accurate. And then if it's a litigated case, and in really any case, you exchange documents so that the other side can see the source documents that back that up in terms of pay stubs, mortgage statements, and bank statements, and credit card statements, and the like. All right, so the financial affidavit is the product of that legal separation. So as I was saying, the legal separation process, you still have to do all this discovery. You still have to collect all this and exchange it and produce these financial affidavits. You still have to negotiate and come up with a settlement agreement and then submit that to the court. The only difference being at the end of that time, a court will approve and it'll be considered a legal separation as opposed to the court approving it and calling it a dissolution. Okay. And if you get divorced through a dissolution, you can remarry, go on with your lives. Legal separation, you're technically still legally married, and thus you can't remarry. Either side can convert it to divorce at any time, but there's no real cost savings, I guess is what I'm going to get at, with one exception, and that is there was a long period of time where people often did legal separations because it allowed a spouse to stay on the other spouse's health insurance. A lot of the insurance companies got wind of that, and many years ago changed the terms of their policy such that a legal separation will also require somebody to be removed from the health insurance. And thus, post-divorce and post-legal separation, usually the spouse is going to have to go to the market to get health insurance on their own, or in some cases, they can COBRA the other spouse's insurance for up to 3 years, but it's still, they would have to be paying the premiums, and that's very expensive. So legal separation used to be more popular because it was a way for a spouse to stay on another spouse's health insurance policy. That still is the case in some cases. Whether or not that warrants a legal separation for divorce depends on a number of circumstances. So that's what legal separation. Another question that people often ask is, how much is it going to cost? Not to give a lawyer answer, but it depends. The more acrimonious a case is, the more it's going to cost. The less acrimonious a case, the lesser it's going to cost, because time is money. We all charge by the hour and how much time we're spending on a case, and that's the biggest factor. We try to demonstrate to our clients that we're being frugal and as cost effective as possible. We make decisions that are not wasteful. For example, with respect to depositions, there's other attorneys that do a deposition in every case. They'll tell you it's because they need to do it to be prepared because they want to know what the answer is before it ever goes to trial. I have a different experience, and by and large, we seldom do depositions because they cost a lot of money. Typically, I can find out the information without doing a deposition. Depositions, a couple hours of prep and a couple hours of deposition, and $400, $500, $600 or more an hour, plus the cost of the court reporter, that can cost several thousands of dollars. So we're very frugal, and we only do depositions seldomly and on occasion with justification that we would talk about with our clients. So that's an example how we try to control cost. We're always trying to just keep it as low as possible. We're trying to demonstrate to our clients that's who we are. So that's our reputation. And that's the driving factor. We're not trying to milk out a few extra hours out of a case file. That's nonsense. Another thing with respect to cost, though, that you have to consider is that the other side gets a vote, okay? Their attorney, whichever attorney they hire, how emotional the other side is. We always just say, let's control the controllables. Let's control our side. Control you as our client and control us as your attorney. And we work together in terms of controlling costs. I know what some of you are saying. Forget about that. But how much is it going to cost? We have found that most of the divorces that we handle that are not in Fairfield County are in the $20,000 to $25,000 range, and per side, per attorney. And in Fairfield County, more in the $25,000 to $30,000 range. It depends, though. Are there kids involved? Are there not kids involved? Is it a high net worth case where there's some more valuations and the like to be done? There are cases that can, even on a divorce case, that cost $100,000 or more, especially if you're fighting over custody. There's also other cases that we do for closer to $5,000, but by and large, those ranges, I hope, are helpful. I've seen published somewhere some studies that were done that said $15,500 per side is what people spend on a case in Connecticut, but I think that's dated. In talking to other attorneys, I feel like our fees and costs are very much in line, and if anything, a little bit to the left of the top of the bell curve in terms of costs. Mediation is 40% less costly than a litigated divorce. And if any of you are considering mediation as a possible avenue, then I would urge you to also watch our Is Mediation Right for You video before contacting us. It will be very helpful to help you decide whether mediation is a good course of action for you. Hopefully you found this helpful, this free consultation, if you will. If you would like to follow up with us, book a discounted strategy session. So instead of a discounted consultation for $275, which is less than any of our attorneys' hourly rates, book a discounted strategy session. We can dive right into your case and start coming up with a plan of attack and talk more specifics and give you a better idea about costs and timelines and the like in your case. Contact us. We'd love to talk to you. Thank you.